So we have Honourable Justice Syed Mansoor Ali Shah, who's the keynote speaker for today's event. He will be talking about mediation in China. It is an absolute privilege to introduce Honourable Justice Syed Mansoor Ali Shah, the senior Puisne Judge of the Supreme Court of Pakistan. Honourable Justice Shah is widely respected as a reformist judge whose work has advanced judicial efficiency, accountability, and access to justice. His contributions to constitutional law, climate finance, and alternate dispute resolution have set new standards for legal innovation and fairness in Pakistan. As chairman of the Supreme Court's Alternate Dispute Resolution Committee, Honourable Justice Shah has led efforts to modernize dispute resolution and ensure timely justice delivery. His landmark judgments and reform initiatives continue to shape Pakistan's legal system. I would now like to invite Honourable Justice Syed Mansoor Ali Shah to grace us with his thoughts and reflections on mediation and China. Thank you, sir.
Assalamu alaikum. Can you hear me? Am I audible?
Yes, we can hear you perfectly.
Okay. So, Assalamu alaikum and good afternoon, everybody. Thank you for that gracious introduction. That was a lot of praise. Thank you so much for that. Let me just, before starting, thank the Center of Chinese Legal Studies, CCLS, Shaikh Hassan School of Law at LUMS, and the Institute of Regional Studies, IRS, for inviting me and for allowing me to say a few words on some of my thoughts that I have on ADR, especially in the context of China. So let me just start off with what the president said himself, President Xi Jinping, talking about the ancient Silk routes, and he says that these routes spanning thousands of miles and years embody the spirit of peace and cooperation, openness and inclusiveness, mutual learning and mutual benefit. The Silk Road spirit has become a great heritage of human civilization. So I'm trying to build on this and take it in the context of ADR in a minute. So the idea of shared community is to foster a more integrated world where there is mutual political trust, economic integration, and cultural inclusiveness. And I hurriedly add into this equation a commonly understood system of dispute resolution. The Belt and Road Initiative, BRI, including CPEC, envisions creating a globally interconnected network of infrastructure, trade, investment, fostering economic growth and cooperation across Asia, Europe, Africa, and beyond. It seeks to build 6 economic corridors, as you're all aware of, and within this framework, the China-Pakistan Economic Corridor, CPEC, serves as a flagship project aiming to transform Pakistan's infrastructure and energy sectors while providing China with strategic access to Arabian Sea via Gwadar Port. Therefore, BRI and CPEC embody a vision of mutual prosperity, regional integration, and the creation of sustainable development pathways. You're all familiar with this, nothing new. A BRI legal framework provides the beginning of a relationship, that's for sure. But it is how you settle your disputes under the said legal framework that defines your friendship. So while the relationship is there, in order to take it to a friendship level, we need to really have a proper dispute resolution system or a framework, which I'm afraid is missing. A uniform dispute resolution mechanism within the BRI and CP network isn't really there as we see today. So I propose, and that's just an idea, and I spoke about it in China also, and I propose a new Judicial Silk Road, for that matter, a new Silk Road ADR system for that matter. This needs to be imagined and built not only between Pakistan and China, but between China and South Asia. And I'll explain that in a minute, that this actually opens up a whole world for us, not with China alone, but with South Asia as such, if we were to build this infrastructure that we're thinking about. Connecting South Asian countries with each other, such level of collaboration can generate the energy which is required to actualize the vision of BRI and CPEC. So we all have a rich past and a glorious tradition of justice and fairness. I don't know about the present though. All we need to do is to understand each other's diverse legal cultures and invent a language of dispute settlement, which is important. A new judicial culture that understands the ethos of a shared community and realize the importance of trade, development, and global coexistence. That's a new language we'll have to talk about, a new language we'll have to develop for our dispute settlement if we need to build any relationship with China or, for that matter, South Asian counterparts, because I think BRI and CPEC gives you another try at something that we could not really succeed, and that was SARC. SARC hasn't really shown much of the results so far, and I think China and BRI and CPEC could be yet another go at the whole regional relationship in building an equation of trade, commerce, and a new dispute settlement and a language of new dispute settlement. So as the Chinese proverb goes, you see, when the winds of change blow, some people build walls and others build windmills. So I say it is time to build windmills of dispute settlement, something like ADR windmills across the area, if you really want this area to develop trade and commerce. So as an extension of China's Belt and Road Initiative, while it focuses on fostering judicial cooperation, harmonizing legal standards, sharing legal practices, and training between judiciaries of participating countries to create an effective dispute resolution system, this is the beginning of a new world of negotiations and settlements as opposed to adjudication and delays of our existing world. I think BRI not only brings a new concept or a new language that of ADR for us, it also helps us build domestic ADR system. It helps build a regional ADR system. So China being at the heart of it, with that energy that China brings to it, we could benefit not only in our relationship with China, but in building our own domestic ADR system, because we're all aware of our pendencies and backlogs and whatever has happened to our justice system now recently. I think our reliance on ADR system is perhaps imperative, and we need to start thinking about that. So I take BRI and CPEC to be a starting point for helping build ADR with China in South Asia and domestically. It could be a huge energy that could come in. So how do we do this? I mean, if you look at China, Chinese culture of litigation and dispute resolution is shaped by a blend of historical, cultural, and economic factors, and we need to see that. Chinese society viewed litigation as a last resort, and these are the lessons we need to learn for ourselves in this relation of CPEC and BRI. Chinese think of litigation as a last resort, often associated with social disharmony and loss of face, as they call it. In Chinese, they probably call it mianzi, which is losing face. So they don't want to do that. They don't want disharmony, and they don't want litigation. They want settlements. So Confucian philosophy emphasized harmony and discouraged litigation, which was seen as a divisive and disruptive to social order. Disputes were traditionally resolved through negotiation, mediation, or intervention by respected elders or local officials. So another concept in the Chinese literature is guanxi, which is relationships. Guanxi refers to the network of personal and professional relationships that individuals build and maintain. It signifies mutual obligations and favors often based on trust and reciprocity. It emphasizes relationships over rigid adherence to contracts, meaning personal trust can sometimes carry more weight than formal agreements. Resolving disputes through negotiations or mediation is often seen as preserving long-term relationships. Court battles are perceived as adversarial and disruptive to business and personal ties. These are lessons we can learn from the culture and history of China itself. So we have had a similar background too. We've had panchayats and we have jirgas, the informal dispute settlement systems in our old community dispute mechanisms that we have. We also, in our religion, if we were to go into that, have a concept of sulah. So there are commonalities that we can build on. And this is the philosophical and the historical or the cultural background to lead us to ADR in future. So it's not only just legalese, it is a lot there. There's a lot of history, a lot of culture that goes into it. So if you look at China, has an estimated of 200,000 judges in the country. And according to the most recent report of the Supreme People's Court of 2023, around 17 million cases of all types were received by the courts nationwide. But 7 or 8 million disputes entered pre-litigation mediation, accounting for 36% of the total disputes, and 5 million disputes were resolved through mediation. That's about 64 to 65% of the cases. So they have a great track record to follow for us to see. So China has established several mechanisms and frameworks to provide dispute resolutions for BRI-related issues. And I think as Pakistanis sitting here, we must immediately see these systems at work. They've done it for China. They don't want to impose it on you. They've done it for China. But we can draw lessons and try to build networks with these systems that are already functioning in China. So the BRI International Commercial Mediation Centers, the Belt and Road Initiative International Commercial Mediation Centers are pivotal in resolving disputes arising from the vast array of infrastructure, trade, and investment projects spanning multiple countries involved in the BRI. Their establishment reflects China's focus on creating specialized mechanisms to support the legal and commercial environment under the initiative. These are the centers we need to study and look at. For example, these centers are in Beijing. The Belt and Road International Commercial Mediation Center, BNRMC, serves as a primary hub, focuses on promoting high standard dispute resolution practices for BRI countries. Then we have the Shanghai Commercial Mediation Center, which supports mediation for BRI projects, emphasizing financial and trade disputes. Then we have Shenzhen, which collaborates with the Shenzhen Court of International Arbitration, and the China International Commercial Court works with the Shenzhen Mediation Center. We have the China Maritime Arbitration Commission, CMAC, which just deals with maritime issues. So the integration of these mediation centers into China's broader one-stop diversified international commercial dispute resolution mechanism ensures disputes are resolved expediently and amicably, contributing to BRI's success. So this is within China how they're sort of envisaging all this. So by addressing disputes with speed, efficiency, and cultural sensitivity, BRI International Commercial Mediation Centers are not just resolving conflicts, they're fostering an environment conducive to collaboration and growth among BRI countries. Coming to arbitration, they have Commercial Dispute Prevention and Dispute Settlement Organization called ICDPSO. They also have other arbitration areas like the China International Economic and Trade Arbitration Commission, CTAC, is one of the largest and the most prominent arbitration institutions in the world, serving as a key pillar in China's dispute resolution framework for domestic and international commercial disputes, established way back in 1956. And the list goes on. We have the Schengen Court of International Arbitration, SCIA, which also provides facilities. It's also known as the South China International Economic and Trade Arbitration Commission, and is a prominent arbitration institution in China, was established way back in 1983. China is also signatory to the Singapore Convention and also the New York Convention. So things are all set as far as that is concerned. And of course, I've mentioned it, but I want to mention it again. The CTAC is one of their major arbitration centers. So these are the centers which are at work, you see, and all we need to do, and I would urge LUMS and other institutions, let's go study them and understand how they're functioning, and we just draw their lessons and bring them back to Pakistan and try to build something here also, and in collaboration with them. So that would be one way of doing this, like sort of Chinese food coming into Pakistan. Let's bring in Chinese ADR into Pakistan. I mean, that's the way to go about it. They're already working on it, and they're very popular, and they're doing a good job at it. So while developing our ADR system, which now domestically talking about ADR system, the Supreme Court and its committee and others are working on it, and we're trying to develop 2 or 3 new things. One is that we want to have, considering that people are sick and tired of the pendency and the long delays in the courts, attending to the court structures and the case management and technology is yet another department, but I'm just talking about an alternative. And we need to provide alternatives in Pakistan. We can't possibly be dragging in courts for 20 years, litigating. So the plan is that we would go out to 138 districts in Pakistan, setting up ADR centers, and ensuring and supporting the fact that we want people migrating onto mediation and escalating their matters to arbitration if required within all these districts. So this is like a community-based culture of ADR that we want to develop by going down to the frontline courts in 138 districts of Pakistan. So that's one vision which we are working on. But at the same time, the Law and Justice Commission of Pakistan has given one of the state-of-the-art arbitration law, which sort of totally gets rid of our 1940 obsolete and archaic arbitration law and brings in one of the most latest arbitration laws. The draft has already been given to the federal government, and we're hoping that they will now put it through the legislative process. In a recent judgment coming out soon, the court has also nudged the federal government in that direction, that we require this new arbitration law, which will also set standards, which will also be a precursor for setting up the International Commercial Arbitration Center in Pakistan, which is also missing, you see. So with this kind of a legislative background, which we're heading towards also sort of revisiting the current legislative framework of mediation and try to see if we can sort of put more energy into it. Even though mediation, as I talk about in the 138 centers, is a case management issue, but of course, if you make it mandatory, that will be even far more helpful. So with that kind of a local climate that we're trying to talk about, we want to bring in legislation, we want to go out in districts and do this. That is required. But in the context of CPEC, we need to, while developing our ADR centers, we need to keep a very pro-commerce bias. We need to create or train or curate these centers which have a clear understanding of pro-commerce. You see, they need to have a pro-approach, understanding commerce and trade. So that is kind of an accent or a bias that we need to develop if we want to develop things along with China. We need to also, as China also does, not every matter could go for ADR, and we need to on the side think of litigation also and try to develop commercial courts. And so in China, we have the China International Commercial Court, the CICC, which also has a focus on understanding commercial matters. And this could be a little island that we could also create of commercial courts in our districts, which would take not that long for deciding matters and have a special focus on deciding commercial matters. We can identify commercial matters, and we could have a special CPEC-related commercial courts, should not be a problem, in order to decide commercial matters as quickly as possible. And considering, this has been said earlier also, there is no way that you can just have one court at the first instance and just leave it to that, because once the matter is decided, there'll be appeals filed and the appeals get stuck in the higher forum and it doesn't achieve the purpose. So then you'll have to have a commercial corridor developed all the way up to the Supreme Court if you want to develop a commercial court system. And that's some of the thoughts that we have on the subject, and we want to develop that corridor in Pakistan to do that, so that we could whatever matters come to court could be taken up all the way and decided expeditiously, because there's a whole corridor dealing with commercial matters. I would just want to say one last thing, and that is the South Asian context. I think this will be a great opportunity, and I see it as rebirth of SAARC, for that matter, the BRI network countries. And I think this is time for us to work on it and try to also get connectivity with the South Asian countries, which is absolutely important. So countries like Bangladesh, Nepal, Sri Lanka, and Maldives in particular, which are on the BRI network, who can work on the BRI framework, must take advantage of this regional commonalities such as geography, location, multi-ethnic population, and similar social structures, who are on the BRI network, to open a fresh chapter of cooperation. And that could help facilitate trade between this region if we were to develop a common ADR regional context with the help of BRI, of course, with the help of CPEC. We could be also engaging with our partners in South Asia, and that would be wonderful to open up trade and have trade disputes resolved through ADR. So there's a whole ADR language going out in the regional South Asian context, a golden opportunity, to my mind, to reconnect with each other, take China's shared community vision of mutual political trust, economic integration, and cultural inclusiveness to the next level, to my mind. So while relationship of South Asian countries and China have transformed into a comprehensive strategic association, there is still no meaningful or perhaps no cooperation between the judiciaries of these countries. So I would imagine that the next step would be that the judiciaries need to talk. Judiciaries of China, judiciary of China and Pakistan needs to talk. Judiciaries of South Asian countries need to talk, because this entire structure of dispute settlement has to be under the wings of the judiciary. And that's how it's going to flow. So I think the judiciaries, it's time that judiciaries get to meet. Conferences are coming up, SCO is coming up, and I would expect that our judiciary will be, getting into this kind of a network, which is important. So it is important to note that the Judicial Silk Road that I talk of, and the Judicial Silk Road or the Silk Road ADR system, will enhance this judicial connectivity among South Asian countries which are on the BRI network, in addition to their direct connection with China. This broader framework can facilitate more integrated cooperative regional environment, promoting trade and economic development through a shared understanding. And it's a win-win situation, to my mind, for not only China and Pakistan, but all South Asian countries, South Asian partners that we have. So we, the judiciaries in South Asia, need to learn from China. And I think that's the message that I want to leave. And not only install such systems for BRI or CPEC disputes in our countries, but also for our domestic system and for the region also. The more efficient justice systems we have at home, more effective and progressive partners we become of China. So in the end, I just want to quote one of my favorite proverbs, the Chinese proverbs, which says that when people work with one heart, they can move Mount Tai. So let's all get together and do something about it, gentlemen, ladies and gentlemen. Thank you so much.
Thank you so much, Honorable Justice Mansoor Shah. I would now request Dr. Sikandar Shah and Ambassador Johar to please share their thoughts before we proceed towards the lunch. I know you're all waiting. Just a few more moments.
Honourable Justice Mansoor Shah, we deeply appreciate your thoughts. Earlier, we had the opportunity to listen to Justice Jawad Hassan and their friend Sikandar Shah Saab, all the distinguished guests. Be delighted that Institute of Regional Studies and Shaikh Ahmad Hassan School of Law, Lahore University of Management Sciences together, उन्होंने मिलके इस बहुत ही फिक्र अंगेज आज की वर्कशॉप का इनेकाद किया है, जिसका मकसद ये है कि जो ये चाइना पाकिस्तान इकोनॉमिक कॉरिडोर है, जो कि पाकिस्तान की हिस्ट्री में, पाकिस्तान की तारीख में जॉइंट इन्वेस्टमेंट का सबसे बड़ा मंसूबा है, तो उसमें जो जरूरत है एक बीफिटिंग लीगल फ्रेमवर्क उसको जो हमारा एग्जिस्टिंग है उसको स्ट्रेंथन करके उस लेवल तक पहुंचाया जाए जिससे कि फैसिलिटेट हो सके हमारा जो ये पार्टनरशिप है, और उसके साथ ही साथ जो दूसरे अमूर हैं ब्यूरोक्रेटिक और लेजिस्लेटिव जो अमूर हैं उसमें, उसके बारे में भी सिफारिशात तजावीज़ की शक्ल में आज के डायलॉग्स से उसमें मदद मिलेगी। हमारी कोशिश ये, अब आप ये देख रहे हैं सारे ग्रुप्स जो हैं हमारे पास, यहाँ पे 60 से ज़्यादा एक्सपर्ट्स हैं, और ये सारे जो उनसे इनको ग्रुप्स में बांध के एक डिस्कशन का जो ये मौका यहाँ पे आज मिला है, तो उससे बहुत ही जामे किस्म की तजावीज़ सामने आएंगी, और वो फिर उसको हम कंपाइल करके जो पॉलिसी मेकर्स हैं पाकिस्तान में और जो भी इस पार्लियामेंट है और बाकी सब वो इदारे जो उस पर आगे काम कर सकते हैं, उनको हम फराहम करेंगे। तो मैं सिर्फ इतना ही कहूंगा कि पाकिस्तान में जो सबसे बड़ी रुकावट है फॉरेन डायरेक्ट इन्वेस्टमेंट के आने में और फॉरेन इन्वेस्टमेंट में आने के, उसमें ये चीजें जो है ना, ब्यूरोक्रेटिक हर्डल्स, फिर ये जो लेजिस्लेटिव के इश्यूज हैं, और सबसे बढ़ के ये जो कानून की अमलदारी का इशू है, कॉन्ट्रैक्ट लॉ की इन्फोर्समेंट है, डिस्प्यूट रेजोल्यूशन के जो मैकेनिज्म्स हैं, उनका नाकाफी होना जो है वो एक बहुत बड़ी रुकावट है, और इसीलिए इस चीज की बहुत जरूरत है कि उस पर काम किया जाए। तो मुझे बहुत खुशी है कि इंस्टीट्यूट ऑफ रीजनल स्टडीज और लाहौर यूनिवर्सिटी ऑफ मैनेजमेंट साइंसेज मिलके आज उस पर एक कदम इकट्ठे उठा रहे हैं, और इंशाल्लाह हमें उम्मीद भी है और हमारी काविश भी होगी कि इस पे एक सीरीज ऑफ डिस्कशंस जो है उनका इनेकाद करें ताकि इस चीज को आगे लेके चलें। तो मैं बहुत शुक्रिया अदा करता हूँ सिकंदर शाह साहब का, उनकी सारी टीम का, और सारे आज जो हमारे एक्सपर्ट्स हैं, सारे इस टीम जो डिस्कशंस हैं जो यहाँ पे आए, बहुत शुक्रिया।
Thank you, Ambassador Johar Salim. I think you've said what I had to say, but I'll still add to the discussion here. I think it's important what Justice Mansoor actually discussed. On the role of universities, and that's what we are, Center for Chinese Legal Studies at the Sheikh Ahmad Hassan School of Law, is the role that we can play, academic institutions can play, research think tanks, to promote an understanding of the Chinese legal system on issues like mediation and negotiation. What we need to understand is that China shares something with us that is those Asian values on how to engage and how to resolve disputes if they do arise. And these are things that we need to understand. And I like the idea. I think both the judges were holistic in their description of both the local legal system, the international legal system, as well as how we can engage with those legal systems. But I think it's important to create that awareness, that understanding, to discuss all the issues that we're discussing here, as all of you are experts in your respective areas, like what are the legislative hurdles, the bureaucratic hurdles, the legal hurdles when it comes to the implementation of CPEC. So in that regard, I think it's this public-private partnership between the Center for Chinese Legal Studies at LUMS and at the Sheikh Ahmad Hassan School of Law and the Institute of Regional Studies, to continue with this collaboration, to share our findings with you, but also to have another, or maybe a series of discussions as we move forward with CPEC, and how we as a whole, as a country, can create that awareness, and your expertise can be shared with the relevant stakeholders, be they politicians or bureaucrats or academics. And this is a nexus between theory and practice, and naturally our contributions are more theoretical, but your contributions here today are going to be practical. So I think it's important to have that nexus in Pakistan. Again, I thank everyone for coming and contributing, and all the guest speakers that we've had, and of course Ambassador Johar Salim and Khalid Saab for your your engagements with us and making this an important event. Thank you very much. And I guess Minahil, lunch.
Thank you so much. Before we all leave for lunch, I would like to share, and in case someone is not listening, I would like to again reassert. Once you return from lunch, and whatever findings and discussions that you had on these tables, to make the most out of it. Of course, we had people noting your recommendations down and everything, but to make the most out of it, and so that other tables also know what the discussion was happening on each one of your tables, I would request the chair of each table to either come himself or nominate somebody from the table to give a 5-minute presentation for an overview of what was happening on your table. I hope everybody understands. So just a 5 to 10 small presentation, verbal presentation, and if somebody wants to present, that is also fine. But just to give an overview of what the discussion was, what were the findings, what were the recommendations, so that other people who are present here at other tables could also learn about what was happening at your respective theme area. Thank you so much. We will now resume. and after this, we will now come back to the hall around 2:30 p.m. I hope that everybody strictly follows the time. And once the session concludes, we will hand over the souvenirs and then you're good to go. Thank you so much, everyone. Thank you for your patience also.